Hey everyone. Good morning. Good morning, Instagram. Good morning, YouTube. Good morning, Facebook. How's everyone doing today? Happy September. I cannot believe how fast this year is flying by. I've been around the world, for a long time, but it just seems like the year is going by super fast in 2021. Good morning, Charles, on Instagram. If this is your first time tuning in, definitely let us know it's your first time so I can give you a shout out. If you are not subscribed to our channel, definitely subscribe to our channel. Like us on Facebook, like and follow us on Instagram. And you can hit the notification button. Once you hit the notification button, whenever I go live or I have an announcement, you'll be able to see it. Hi, Macedonis from Facebook and Washington State. Definitely say hi in the comment. Let us know where you're tuning in from, as always. So for those of you who don't know me, or those of you tuning in for the first time, my name is Aisha Chidoe. I'm an immigration attorney, and I represent clients all over the United States with their family immigration matter. So your state location doesn't matter because immigration is a federal law. So generally, most attorneys can represent you regardless of where you live, as long as you want to immigrate to the United States. So if you want to reach me, my phone number is 407-995-6567. And if you're on Facebook and Instagram, it's scrolling through on the ticker on the bottom. And if you're on Instagram, you can see it right there in my profile. So you can definitely reach out directly to me. Hi, Destiny. Good morning from Orlando. So you're here where I am. Somebody says, Morgan jumps right into it. How long does it take for you to get your work permit after your fingerprints? So the answer is that it really depends. I always say, give or take, give it like 8 weeks. And, as I always say to you guys, when I give you guys caveat, it doesn't mean that that's when it's going to happen. I just give you an estimate based on what I know, what I have seen. But it could be less than that. But usually, before 8 weeks, hopefully that's when you'll get it. And this is saying this based on not knowing what you took fingerprints for. But if you took fingerprints related to like a 485 or your work permit, that's what it's going to be. Destiny says, looking beautiful as usual. Thank you so much. I appreciate that. Okay, guys. So I have a good topic for you guys today. Today, I want to talk about the different types of relief that you can get, based on abuse when you're either married to a green card holder, a U.S. citizen, and you the difference is when you have a green card and when you don't have a green card, because a lot of people get this confused. So let me start with the two different things first of all. So a conditional green card means that you are a green card holder. So that's the first thing, because it confuses a lot of people. It means you're a green card holder, and then when you have a conditional green card, after 2 years, you have to remove the conditions in your green card. Normally, in order for you to remove the conditions in your green card, you need to sign with your spouse. You guys need to attend the interview together. Sometimes they bypass your interview. And once that is done, they will remove the conditions and give you your 10-year green card. However, there are times when there is abuse that occurs in a marriage that does not allow conditional green card holders to file with their spouse. Now, so keep that in your mind. Now, there is also something called VAWA petitions. VAWA petitions apply to non-green card holders who are experiencing extreme cruelty and abuse. And they are also married to U.S. citizens and green card holders. So the difference between these two things. So, a lot of people get this confused. Like they will say, I want to file a VAWA petition. I already have a green card, a conditional green card. My spouse is abusive. So the thing is, you can't submit a VAWA petition when your spouse is abusive and you have a green card. You can, however, submit a request for a waiver based on your spouse being extremely cruel and abusive. So it is semantics, but the rules are a bit different, Okay, the rules are a bit different. So it's semantics, but it is not the same thing. So, with a VAWA petition, you don't have a green card. And what we're submitting in that case is an I-360 petition. In that example, you're going to need to provide a police report of good moral character for the last 3 years, showing that, you don't have any crimes of moral turpitude, you're a good citizen, and things like that. For a conditional green card, when you want to remove it based on abuse, you don't have to submit this, okay? You already have your green card, so we're not starting afresh. Both of those two different examples both still require you to show you have a good faith marriage. Like, you can't just, submit a petition and there's really nothing to show that your marriage was legitimate. You still have to show the legitimacy of your marriage. However, and this might be my personal opinion based on my experience of handling a lot of these cases, these two types of cases, what you generally see is that the standards to show a good faith marriage are much higher when you have a conditional green card than when you're submitting a VAWA application. And I will explain that in a second. Let me pause. I wanted to say, if you guys have any questions, I don't know if some of you are just tuning in now, please leave your questions in the comment box. Today I have some time. I have like a good 30 minutes. So ask your questions because I will try to answer all of them, or as many of them as I can within the time I have. If you're just tuning in, give us a shout out, comment, say hi, let us know where you're tuning in from. Like my page, share this video, share this live, share it on Facebook, share it on WhatsApp, because you never know who needs this stuff. A lot of people might not talk to you about what you're dealing with, but this might be helpful for them. So I've completely lost my train of thoughts right now. Okay, yeah, I remember what I was talking about. So as I was saying, let's talk about standards. Hi, Yummy. Good morning from YouTube. Hi, Starboy. Good morning. Macedona says, I gave your number to my friend yesterday. She's married to a U.S. citizen 25 months ago. She has 2 girls in her first marriage in Africa, but she came to the U.S. and now her husband wants to adopt her children, but they don't have a green card. Okay, thank you for the referral. Thank you. Okay, so definitely put your questions. I'm going to get to it. So I want to talk about standards, when you're dealing with a conditional green card based on abuse and a VAWA application based on abuse. So when you don't have a green card, you don't have a social security number, because likely you came in here, either you crossed the border or without inspection, or you overstayed on your visitor's visa, or something else. I mean, sometimes if you have an H-2B or an F-1, you might have a social security number or whatever it is. But when you fall into a true VAWA application, a lot of times you are not going to have as much bona fides as somebody who, one, has a conditional green card. Why? Because one, you might not even have a social security number. So if you don't have a social security number, there are many limitations. It depends on where you guys are renting. Some places will not allow you to list yourself. Some places will not, some banks, even though there are some banks like Bank of America, which will allow you to get a joint bank account, even if you don't have your papers, but there's a lot of limitation as far as getting a lot of stuff to show a bona fide marriage. And also because when you're in an abusive marriage and your spouse is stopping you from doing that, it is much easier for them to do that to you when you don't have any paperwork. You don't have any proof. I find a lot of VAWA applicants will say, when I say, well, why, I know the reason, but I still ask them, well, did you go to the cops? Why didn't you go to the cops? Why didn't you report to the police? For a lot of these people, there is a great fear of deportation. There's a great fear that your spouse will look, if you call the cops, it's over for you. It is over for you. Or if you call the cops, they're going to believe me because I'm the U.S. citizen. If you call the cops, they're going to believe me because I'm a woman. I'm sure you can figure out all the rest of the examples that I'm about to say with that. So a lot of times they don't call the cops because they don't want to end up being the one that goes from the abuse to the person that's in jail, because we see that happen all the time. Like, I have had clients who were not even in the house. they were somewhere else. They had another alibi. And cops showed up to their place of work to arrest them, that their spouse said they were beating them when they've not seen their spouse in like 5 months. So this is real. Like, people really frame people. So in situations like that, it is much more difficult when you have a VAWA case or when you don't have a green card at all to have as much bona fides. So the standards are more accepting of why you don't have certain things. However, if you have a conditional green card, what does that mean? It means you have a Social Security, your green card allows you to work, your green card allows you to travel. So the standards become higher when you don't have bona fides, because, when you submit your petition, to get your green card, normally for most people, you get your Social Security even before you get that conditional green card. And so at that point, quote unquote, things are supposed to be good. So they expect to see more bona fides. They expect to see, bank accounts. They expect to see taxes filed. They expect to see trips, that you guys went to, Kentucky, any random location. They expect to see more of that. And they also scrutinize you more when the cops have not been involved, just because, at that point, you're not as worried that you're going to get deported because you have a legitimate green card. So they scrutinize it. And don't get me wrong in what I'm saying in terms of this. It is still not a requirement to have a police report. It is still not a requirement. We've got many approvals without a police report with conditional green cards. But what I am saying to you is that if you have a conditional green card, the evidence that is required or the standards are much higher. It's much higher to show proof of your abuse, to show proof, of what's happening to you compared to, say, if, you're a VAWA applicant. However, both of them lead to the same thing. If they remove your conditions based on abuse, or if you get approved and a green card based on VAWA, you will still get a 10-year green card. And with both scenarios, you will still be eligible to become a U.S. citizen within 3 years of having that green card, whether or not you're divorced or not. The other critical difference is that if you are a VAWA applicant, you cannot, let me repeat that, you cannot remarry somebody else while your case is pending. You have to wait until a decision has been made on your case before you're approved. Some people say, well, I had a child after. I don't care that you had a child. USCIS doesn't care that you had a child. If you're not in your relationship and you met somebody else and you had a child, well, that's okay. Just don't remarry until you finish the process. So those are the critical differences between the two. So I'm going to take your questions now. Somebody says, what if my husband abandoned his wife and his family taking care of her? What can happen? If Morgan, so the answer is that it depends on what your status is. Are you a green card holder, conditional green card holder, or do you not have any paperwork at all? I suspect that with abandonment, there are certain levels of extreme cruelty that is existing in there, because abandonment is extreme cruelty. But usually I need to screen you to see what else is happening or what else has happened in your relationship to determine whether or not you qualify to self-petition by yourself. So there is still a way, or there is still hope, but we definitely need to screen you to see what it is. Good morning, Christ from Dallas, Texas. Starboy says, my I-360 was approved 2 months ago. My abuser was a permanent resident. How long until I hear back or go for an interview? The answer is that it really depends. It can take anywhere from 2 months to 6 months. So you just have to sit tight, but you're almost at the finish line. These cases just take a really long time, but the end is worth it. So just sit tight, and hopefully in the next few months, you will either get an interview. Sometimes what we're seeing right now with some of the VAWA applications is that sometimes they will bypass an interview. Not all the time, or not majority of the time, but sometimes they will bypass it. And what they will do is they'll send you an RFE to send your medical exam records. All right, let's see what we have on Instagram. Somebody says, OJ says, is prima facie a good sign that a VAWA petition will be approved? So, so let me answer this question carefully. So a prima facie is not a guarantee that your VAWA petition will be approved at all, but a prima facie is a good sign that you have met what USCIS considers to be the minimum standard. You've established the minimum standards to be considered eligible for VAWA approval. That being said, once they give you the prima facie, they still now have to go through a granular detail of everything that you have submitted to make sure that based on your submission, that these things did in fact happen and that you are in fact eligible. But it is a good sign that your case is moving in the right direction. Okay, do you guys have any other questions for me? Sorry guys, on Facebook, I am scrolling through Instagram in case you're wondering what I'm doing. Okay, I'm gonna wait about 1 minute to see if there are any other questions or if I missed anything. Okay, so this person says, Cecilia says, what happens if I went to the States on a visitor visa and marry a U.S. citizen, or if I stay in the States over 3 months with my U.S. girlfriend who's supposed to be my wife? This is a question from a friend of mine. Well, is it your girlfriend or your wife? Because girlfriend and wife are two different things. What separates them is a legal document. So if you have a legal document that says somebody is your spouse and the person you're married to is a U.S. citizen, you know, after 3 months, you can definitely self-petition for them. One of the things that you want to be careful, though, is when you are applying for that visa to come in here, that you want to make sure that you're not saying or lying that you're not married, because then you're going to have to deal with misrepresentation and getting a misrepresentation waiver. I mean, if you're like, I always take the path of be honest, be transparent, or whatever it is. Or if you already have your visa, it just might not present itself, that question. But generally, if your U.S. citizen spouse is in the United States and you're in the United States and you're married and it's been more than 90 days, you can definitely self-petition as long as, you are clear that you didn't lie in any other stuff, like so in your application for that visa or on entry with Customs and Border Patrol. Okay, somebody says, how long does it take to get a work authorization while waiting for a VAWA approval? So the answer depends, because with the VAWA case, there are two types of work authorization that you can get. So one is if you filed your VAWA application with an adjustment of status application, which is the I-485, and you also submitted a work permit based on the I-485, usually you're looking at a 6 to 8 month timeline of when you get the work permit. However, if you didn't submit an adjustment of status application or you submitted the wrong category in your work permit, you won't get a work permit until you are approved for VAWA. And that work permit is different because that is an approval work permit. It's weird because the work permit for VAWA standalone or VAWA comes before the actual approval letter. Like sometimes it can come like 6 months before the actual approval. But when we get that card, we know that that is an approval based on the category that's listed on that card. So for example, let's say, you filed an adjustment of status application with your work permit and your VAWA application. In 6 to 8 months, you'll get a work permit. That work permit just is basically saying that your case is pending. And because your case is pending and you qualify based on you being married to a U.S. citizen or an in status or visa available green card holder, we'll give you a work permit. So you have that work permit. And then when your case is approved, you'll get a new work permit. That work permit is a different category from the first work permit you got. But that work permit basically tells us your case has been approved. It's just that they send a letter of the actual approval a few months later. So those are the two different types. It depends on where you fall on the pendulum. Somebody says, how do I know when my case has been transferred to the National Visa Center? Because you're going to get an email, and a letter saying that your case has been transferred, and it's going to give you your, your NIV login information of how to log on to the National Visa Center to complete the other portion of the application. So once your case is transferred to National Visa Center, and for those who don't know what that is, that's if you are doing anything related to consular processing, meaning processing your case or your family's case outside of the US, whether via fiancé visa or family-based visa, they send it to the National Visa Center after they've approved the USCIS initial application. And at that point, you have to fill out the application forms on NVC, submit your affidavit of support. And then once you submit your affidavit of support, then and fill out the forms and pay the fee, then it will move over to your local consulate. Okay. Somebody says, did you say that VAWA applicants cannot get a divorce and remarry? No, I did not say that. And so let me say that loud and clear. I did not say you cannot get a divorce. I said you cannot remarry while your case is pending. What you need to do is wait till your case, a decision has been made on your case. And then if you want to remarry, you can remarry after that. But can you get divorced if you have a VAWA case? Absolutely. You should get divorced if you're dealing with a crazy psychotic person in the first place. You can get divorced. And even if you're divorced before you submit a VAWA application, you can do that. You just have to wait until, you just have to submit your VAWA application within 2 years of your divorce. So if you come to me and say, I've been divorced for 3 years, the final divorce decree is 3 years ago, we will not be able to submit a VAWA petition. You must do it while your divorce is under 2 years. So I hope you understand the difference. I don't want anyone to be confused by that. Abugo says, is it possible to withdraw a VAWA case? Yes, it is possible to withdraw a VAWA case. You will have to submit a withdrawal letter with your receipt number, letting them know that you want to withdraw your case and the reason why you are withdrawing your case. Yes, you can withdraw it. Okay, let's see what else we have here. Okay, I think, have I answered everything? Am I missing something? Let's see. Okay, do you guys have any other questions? No other questions? Okay, guys. Well, I hope you have a wonderful Thursday, and I will be back here around same time, somewhere between 9 and 9:30 a.m. tomorrow. And definitely hit the notification button on my Facebook page or my YouTube page and my Instagram page so that you know when I go live. I would love for you to share this video because, you never know what people are dealing with and how helpful this video might be to them. Send it to them on Facebook, WhatsApp, and, wherever else. Okay, I see 2 more questions that I'll answer before I jump off. Somebody says, what can you do when your ex-spouse refuses to sign a joint divorce paperwork? Well, whether they choose to sign it or not, the court is going to grant default judgment after some time. So that is very state specific. It's not federal law, and I'm not a family attorney. So I don't want to give you any kind of suggestions as far as that, but I can tell you that you can still get divorced if they choose not to sign it or not. It's just that it will take longer. But if they keep trying to serve them and they're not willing to do that over time, they will, depending on your state and how the rules work, you'll be able to get like a default judgment if you've done everything that you can. In that case. And then Nat says, suppose someone marries and files for VAWA, should he or she move out or file the same? I'm not sure I understand your question. Are you saying that if you file VAWA, should you still live with your spouse? Is that the question you're asking me? So the answer is that it's really up to you. We have people who file VAWA cases and they never move out, or they never still have the courage to move out of their spouse's houses until they get their approval. Or some of them, choose to forgive their spouses. That is on you, if you choose to forgive your spouse, I can't control that. But there is no requirement that you should stay or you should move out if you have a VAWA petition. That being said, a lot of states will not give you, when you get your prima facie determination letter, prima facie determination letter allows you to receive public benefits and public assistance, but it's state specific, and a lot of states will not give that to you if you're still living with your abuser. So they would want you to move out. So it just depends on your state. Emeka says, I didn't answer your question. Okay, let's find your question. Emeka says, can I have a child with another girl while my VAWA case is pending? Well, I mean, they're not going to deny you based on that, but you just can't get married. You just can't remarry somebody else. But, if you have a child, it's what it is. So Destiny says, I wanted you to talk about the VAWA case when you're not getting no money at all from your spouse. So are you saying basically, financial abuse is a real thing, a lot of times, when you're dealing with VAWA cases, people think that abuse is only physical. And a lot of people that think that, especially, culturally, depending on your culture, as far as you're concerned, they're not beating you up, I had a client who just recently got approved for his conditional removal based on abuse. And I did post that yesterday. And I know that, with that client, some clients struggle to accept what is happening to them as abusive behavior, because culturally or societally, they're like, well, this person never beat me. This person never slapped me. This person never choked me. But abuse can occur in the form of finances. It can occur in the form of emotional. It can occur in the form of psychological. A lot of times, if you have a spouse where let me give you an example. Your spouse knows that you don't have a job, you don't have papers, you 100% rely on them to support you financially, and they don't give you money. When you go buy something like groceries to cook in the house, you need to show them the receipt. They need to inspect the fridge to make sure it matches the receipt, like you're a criminal. They don't allow you to even you buy feminine products. We have some crazy stuff like that happens where they're like, nope, whatever I buy is what you're going to use. If you need things for your personal upkeep, you can't get it. Those are all abusive behavior. That's extremely cruel. So, that I suspect a lot of times leads to a lot of emotional abuse. So it's never one or the other. Like in my experience, people usually fall into several categories because it's like a trickle down effect. If they're doing that to you, you can't buy personal hygiene products. That affects you. That affects you emotionally. So you move from financial to the emotional side. And somebody that does that likely does other things that's either verbally abusive or psychologically abusive. So one thing only doesn't disqualify you. And that is why screening is important. And what I mean by screening is having a consultation, so we can ask you questions to see where you fall, along those lines. Okay. So Rayon says, my wife is refusing to do my documents for my green card process. What can I do? So Rayon, I would definitely suggest, a consultation with me, because those are telltale signs of somebody who is abusive. However, it's good to screen just to see what's going on and to also make sure that you meet the requirements. Because even though your spouse might be abusive, you might not meet the requirements, because there's still other things that we have to ensure that you meet to make your case a successful one. Somebody says, can you travel outside the United States while your case is still pending? Many attorneys discourage their clients from travel out of the States. What's your position, Everest? So the answer is that it depends. It depends on what your status is. So if you are in removal proceedings, if you enter the country without inspection, I don't recommend traveling outside the country, because sometimes USCIS will make a mistake and grant you a travel permit. However, if you came into this country with inspection and you overstayed your time, and you're now married to a U.S. citizen and you're filing an adjustment of status based on marriage, and you get a travel permit, or you're filing VAWA and you get a travel permit and you fall into that category, you entered with a proper visa, you're not in removal, there's no problem. Obviously, the caveat is don't go out of the country and go stay there for like a couple of months. Stay there a week, 2 weeks, and come right on back, because you don't want to be stuck outside. And if COVID-19 hasn't taught us anything, you've seen how with the pandemic, people got stuck outside the country. So because we are still kind of in a weird time in the world where there is this pandemic that's so unpredictable. Now we have a Delta variant, it's like you take several steps forward, several steps back. So you don't want to go out for a long time, and you want to make sure that wherever you're going to is not one of those countries that's a level 4 country where there's a possibility that US can shut the border or close it down. Because remember, you're not a US citizen, so US doesn't have allegiance to allow you back into this country. Let's use the UK, for example. A lot of people that want to come to America from the UK that are not US citizens are having to go out to another country to come into America through that country. Yes, if you're an American citizen in the United Kingdom, they will allow you to come because this is your home. But you might not with, if you're from somewhere else. So you got to be careful with that. But, if you fall into the other category I just mentioned, I see no reason why you shouldn't be able to travel. So, all right, let me answer this question on Instagram. So what can we do when you fill a form twice online? So the question is too vague. I don't know what form you're talking about. So you got to explain that better. Okay, guys, I really do have to jump off now. I actually have a meeting. All right, I hope you have a great day. Come back tomorrow if I didn't answer your question. Love to answer your question tomorrow. Okay, bye.